So I thought we'd now talk about challenging behaviours in another way and around the security of tenure issues. So let's have a look at Frank. Would someone like to read that out?
Frank is 79, has dementia and challenging behaviours. He is a large man and quite strong. He is often verbally abusive, but lately his behaviours have been escalating. Staff have tried everything, including engaging specialists, doing full assessments, and implementing a range of strategies. Unfortunately, Frank punches a staff member and pushes over a resident. Waterview discussed the possibility of moving Frank to another facility, but the family refused to allow this. They blame staff for Frank's behavior. The following week, Frank pushes the resident again, and this time she breaks her hip. Frank undergoes an assessment by a psychogeriatrician who determines that Frank is aware of what he is doing but has no insight into his behavior. He is of the view that Frank has a personality disorder.
So what do you think are some of the things that the facility could do? What are the options here for?
An option would be to keep on pursuing it and then get him into a facility like Trevina that specialise in those behavioural issues.
Yep. I mean, now I think, the facility's tried a lot here, and perhaps they could get some more strategies from the psychogeriatrician to try those as well. But it may be that, there's not much else you can do.
Do they have to give carry over residents too?
They do. And the staff.
Yes.
Yeah, exactly. So there are some real legal issues that arise here from Frank's behaviour, and you do need to weigh up that risk, put a risk management plan in place in order to fulfil those obligations. So here are your two key obligations that you have to consider, as well as Frank's best needs. We also have to look at occupational health and safety law, which says that employers have an obligation to provide and maintain for their employees a safe and risk-free working environment as far as reasonably practical. And also other residents' rights under the Charter. They have that right to live in a safe, secure environment. So Frank's putting that at risk.
So from that point of view, the family can't really refuse, or can, over time as things become evident and everything's documented, does the family have a say in, can they still refuse for the person to be moved?
Yeah, well, it becomes a question of whether you've got a ground to ask him to move under the security of tenure provisions, and that's what I'll sort of explore a bit more lately. But I mean, those, as well as what's going on with the security of tenure, have to be thinking in the background around these other risks and managing those as well. So
could you take the families with the VCAT and so?
Possibly, yeah. It could be that they're not acting in Frank's best interest because Frank shouldn't be in this facility. That's going to be harder because, when this sort of thing comes up, sometimes the department will say, well, it's your fault, you're not managing Frank properly. Yeah, you need to effectively have one-on-one care or something for him, which is, not a very good solution, but the problem is too, when VCAT look at it, they'll look at it from Frank's perspective. They don't look at it from the resources of the aged care provider. They'll be going, what's the best thing for Frank? And we've actually got a scenario at the moment with a lady who is in a retirement village, and she's quite advanced dementia. Family just don't want her to go into aged care, and the OPA's looked into this, and even though she's sort of at risk, the OPA thinks it is best she stays in the retirement village because they're looking at it very much from her perspective and where she would want to be, rather than looking at the resources available to make sure she doesn't sort of harm herself. And that's, she's in the independent living unit, so that's a case where really the provider doesn't have much responsibility to protect her. But even so, VCAT are saying the best thing is for her to stay there. Or, well, they could say that's what the OPA are saying, so it could be that VCAT have the same view. We don't know yet. So there's other responses you could do to Frank's behaviour and this will depend around his capacity as well, but giving a written notice of the breach, saying you're breaching your obligations as a resident, under the Charter of Rights and Responsibilities, saying that it's unlawful and saying, you know, if you continue this behaviour, we may ask you to leave. Also entering into a behaviour contract might be one strategy. But, you know, for someone who does have dementia, all of that's advanced dementia, that's not really going to, none of these strategies will really be that useful. Just on the behaviour contract, we sometimes use that with family members who are badly behaved, so that's another one to keep in mind. But really, in some cases, the only thing we're going to be able to do, or the only real option, is to ask Frank to leave. So the Use of Rights Principles 2014, nothing's changed since the old ones, so it's still the same kind of grounds. But the two grounds that would apply here is where the care recipients intentionally cause serious injury to another resident or serious damage to the residential care service. The service no longer provides accommodation care suitable for the care recipient, having regard to their long-term assessed care needs. The fact that a resident has breached their responsibilities under the Charter is not enough. So just because Frank is not respecting staff's rights to work in a safe working environment, which is one of his obligations, does not mean that you can ask him to leave on that ground. Those are the only real two that could apply here.
A serious injury includes psychological injury?
Yes, it could. It's a more difficult situation now. I mean, with Frank's situation, we've got a lady breaking her hip. I think that's serious injury, and but yes, that psychological injury could also.
I think like what Bernie's trying to get at is maybe if there's a lady in one of the beds and a man's coming in and intimidating her every night, or you know, she's feeling threatened or intimidated.
Yeah.
Where do you stand there? Yeah.
Yeah, well, there's certainly an argument that that could be a serious injury.
What about on the staff? I'm saying, what about on the staff as well? Because you have such a resident, and they know each time they have to attend, there's a high risk that maybe you come out of that room with a black eye. So staff ended up feeling like uncomfortable. They will just go and do it for the sake of money because they want to keep their job. But psychologically, it's something that is not okay.
And in the workplace health and safety context, there's a lot of authority for staff suffering psychological injuries is a breach of the workplace health and safety law. So yeah, that's definitely the case there, that the employer's not fulfilling its obligations to staff. You have to maintain that environment, that safe working environment, as far as reasonably practicable. And I think if it got to a sort of Fair Work or work cover, they would be saying you need to do more to protect your staff here because you're breaching your obligations under that law. So yeah, staff should not be getting black eyes at work.
Where would you stand as a manager? So you did have an aggressive resident, you knew that the resident was aggressive, and you're continually getting incident reports from your staff written about injuries that they're getting, say 4 or 5 incident reports in a short space of time. Where would you stand there? You have to be very considerate of what the staff are going through, wouldn't you?
Definitely, and I think you need to be taking some steps to manage that risk, and that'll be, whether it's getting staff some training in managing that challenging behaviours. Also assessing the resident, getting them assessed to see what else you could be doing to manage those challenging behaviours. Yeah, there's really, you want it to be documented well, because workplace health and safety legislation is not something you want to be breaching. There's quite serious fines for that, so that should always be, of all the risks, if it comes down to breach the OH&S law or breach someone's security of tenure, our recommendation would generally be breach someone's security of tenure. The worst the department could do is sanction you, and the chances of them doing that, if you've done everything you can, well, that's fairly low, and it's probably something that could be managed. But workplace health and safety legislation, not only have you got that, you could have a work cover investigation, you've got to pay the insurance on that, and it affects your premium. So that's I think more teeth really to that law. So, and it can be a criminal offence as well to breach that law. So, whereas breaching someone's security of tenure is not a criminal offence.
Anita, does the same thing apply if you as a manager become aware of bullying among your staff group?
Yeah, definitely. Bullying is another form of workplace violence. So it also needs to be managed in the appropriate way. So whether you need to investigate those allegations and take whatever actions appropriate. And I think there's some good investigators and mediators and the like out there that do that, sort of specialise in that. So yeah, definitely. And bullying allegations, unfortunately, they're sometimes made too frequently and by the staff who are the bullies themselves, but they still need to definitely be taken seriously and responded to. One of the workplace safety laws changed, I think it was perhaps earlier this year, such that a staff member can now basically go down to Fair Work and take you in for a mediation and say they've been bullied, and it's the first you've ever heard of it. Whereas previously they had sort of escalated that internally, but now you might just be pulled up and suddenly you're in a hearing effectively about that. So bullying is something that, I mean, things like that, Brodie's law, the case with the girl. Yeah, bullying is considered quite a serious issue. I think the term's maybe abused a bit sometimes, but and Libby Pallow, who works in our employment team, she's an expert on these things. So if anyone has any questions about that, but yeah, it is definitely another risk that needs to be managed and similar to those.
I had a case in when I was on a different floor when a lady, she stayed in a share room, but because she, her roommate passed away for a long time, so she stayed in that room for quite a few months, and then we put another resident in. So that lady doesn't have dementia, but then she kept bullying another resident. So she assaulted, verbally bullied the other resident, and she had a way, to bully that resident. So the resident wasn't happy with it. They argued all the time. So the management, took in, and then they decided that now it's time to separate them. And now the co-resident didn't want to change to another room. Because she thought that if she moved to another room, that bully resident will bully other residents as well.
Oh gosh,
so
it's a no-win situation.
Yeah, but then we got on the GB psychologist came in, but then it's a what is it? Personality disorder. So we can't do much about it. And she's very smart. She knows that if she keeps doing it, she's gonna have that room by herself, because she doesn't want to be in a single room, because a single room is much smaller than that type of room. But then there's nothing much we can do, because the other co-resident didn't want to move as well. So she wanted to fight with that lady. I don't know how it went though. They're still in the same room.
We got along really well.
Oh, they got along really well.
The lady one, she stand up for her somehow. So she won. And staff have some strategies as well. So because that lady was jealous as well, that's why she's bullying the new one. And then they just agreed to her first, and then come back, said be quiet, and then talk to the new one. So they have strategies as well.
Yeah, and perhaps just going back.
But then, personally, I don't think the co-resident should suffer, any harm.
Maybe those kind of steps might also be ones you think of there, just giving her something formally, because bullying someone's a breach of her obligations as a resident under the charter. So saying to her, you're breaching your obligations, your resident agreement says you have to comply, and we take this very seriously. Difficult.
But because she's very smart, whenever we away, she started to bully. Like when the staff was not around, she started to bully the co-resident. Turn the TV home night and blah blah blah. She's very smart.
I think putting something in writing to her, say next time there is an issue raised, I think that is a smart thing to do, just because you've put her on notice effectively, and if it ever gets any worse and you want to ask her to leave, well, you can show that you've put her on notice. So sending her a letter saying, this is not acceptable, and here's the behaviour management contract. You need to say sign saying you'll be respectful to others. I think that's another step you could think about in that case, because she's probably not going to change her behaviour, but you want to show you're doing everything you can as well. So the first, with Frank, just looking at the the causing serious injury background, the first question is going to be, does Frank have capacity to actually to form an intent? And we've sort of spoken about this issue before. That psychogeriatrician, I think, said he does know what he's doing.
What he's doing.
Yeah, so when we're talking about intent, it's not quite as high a threshold to say someone having understanding and being able to give informed consent. You could be quite drunk and still intentionally hurt someone. The fact that your capacity is somewhat lowered by being drunk doesn't mean you can't form that intent. You have to be, it's almost, not, as long as you can understand what the action you're taking, even if you don't fully understand the consequences, it may still be that you have that intent there. So I would say arguably Frank does have intent despite the fact he has dementia. So the fact someone's got dementia does not mean straight away they can't have intent. So you need to assess that person's capacity to make that call on whether they do have the capacity to form the intent. So serious injury, well in this case we had the person with broken hip, so we're probably over the threshold there, but that's often a tricky one. So what's considered to be serious? It'll depend on the facts of the particular case, but what if someone's just slapping residents? There's bruises, is that serious injury? Probably not if it's a once-off. It depends if that's accompanied with other sort of threats and stuff like that. What about a long-term alcoholic who, whenever he engaged in drinking binges, would return to the facility and physically threaten staff without actually assaulting them, but he verbally intimidates them? What about someone who makes racial taunts, for example? Is that a form of serious injury? I think those cases are where it's going to be a bit trickier, but that's not to say there isn't serious injury. So a serial bully cannot be dealt with by asking that person to move on. The provisions seem to contemplate injury of a significant and serious nature before the resident could be asked to leave. But nobody would argue it's acceptable for a resident to continually bully someone. It's just that may not actually be grounds to ask them to leave. Now, the other one, we've got George here. George, do you want to, would you mind reading it again? Thank you.
George is 84. He does not suffer from dementia. Lately, staff have noticed that George is spending time with Lula, who has severe dementia and cannot communicate. One day, staff find George in Lula's bed naked. Staff believe they may have had sex, however Lula seems perfectly happy. Staff report the incident to the department and to police, as well as to both families. Lula's family are horrified. They demand that George be removed from the facility, saying that he has sexually assaulted Lula because she can't consent. Police don't do much. When they do come out to interview staff, they say that it is too difficult to do anything because there are no witnesses. George's family say that staff made the incident up.
Yeah. And this is not too far off a scenario we've come across. So, yeah, unfortunately we've got Lula. She can't say anything anyway and doesn't appear to be making a complaint. But we've got this guy who, you know, he does have that intent and he probably should be able to understand it. But the question is, have we got a serious injury? Lula's fine, she's not physically injured, but she can't consent to sex. So case law would say being sexually assaulted, even if it's not left you with any physical harm, and this is more in a criminal context, but the fact that you are indecently assaulted is of itself a serious injury because your rights have been infringed. Applying that in this security tenure context, maybe the department may not agree. This is not sort of straightforward stuff here, But what I'm saying is that it is an argument that that sort of scenario could be a case where there's been serious injury. There's also been cases where someone's been sued and been given and had to pay quite significant damages for indecently touching someone without their consent. So I think, again, that shows that the fact someone's rights are infringed on can in itself be a case where they've suffered injury. It recognises that the indignity and humiliation a person suffers when she or he is the subject of non-consensual indecent contact is a damage or injury in itself, and the amount of compensation can be increased if there's also physical injury. George, he has intent here. He's caused serious injury, we could say. That could be controversial, and George's family will no doubt disagree. But there is grounds to ask George to leave from a legal standpoint. Maybe a bit of an argument to have with the family and or the department, but that's not to say we couldn't make it out.
So the serious injury is a legal concept rather than an emotional experience for her.
Yeah, it's illegal and it's it's a difficult thing to assess, but there is a sort of objective assessment of whether something is serious injury or not. So the fact that she's not making a complaint doesn't mean,
regardless.
She can't communicate, and she has severe dementia. I mean, those people are usually vegetating, aren't they?
Well, she hasn't got, maybe she doesn't have verbal capacity to communicate, but are there non-verbal indicators of distress?
She seems perfectly happy.
The severe dementia, though, I mean, if you look at the residents who have, the elders that have severe dementia, they're usually in a fetal position in bed, they can't communicate anymore.
No, hang on a minute. We're talking about people on a big continuum here.
Yeah.
Many of whom lose language verbally, going back here, but who continue to have capacity to communicate non-verbally to us for months and years. So very rarely do we actually see people in a fetal position these days. That sort of experience doesn't happen very often.
That's good.
We see people at end-stage dementia, and maybe for a month, maybe a week, maybe a couple of days, they're in bed.
We have a few elders that are in bed like that for over 4 years now.
Sure. Not today.
I think another scenario you might think about is what if someone's in a coma and they get raped? You know, they don't know what's happened to them, but I think that's still one would say a serious injury.
But can you say that because
assault to them?
Yeah.
because they don't have short, or their short-term memory is so diminished or maybe non-existent in some cases, that they might appear to be happy because their mind is in a different place. They don't necessarily remember what happened yesterday or a couple hours ago when they were touched. They don't remember it.
Yep.
So they're going on and they seem quite happy and quite normal, but they've been on some level that they can't access at the moment. They've been traumatized, but they just don't express it. Is that a possibility?
Sorry, I don't understand why this guy is serious injury, because we didn't see anything and he might not have sex with her.
Yeah, look, that's another question. Let's just presume that he did. Yeah, or in some other way assaulted her or touched her. So I probably should have made that a bit clear.
What we found, he was naked on her bed.
Yeah, I think that sort of suggests that maybe...
Yeah, that's not a normal thing to do, is it? You know, like
someone is cognitive, not suffer from dementia.
Just getting back to your point too, I think regardless of whether the resident, take the coma patient, they're not going to know anything, they're not going to be psychologically damaged in any way from what happened to them. But it's the fact that they're right.
Oh, no, I do think that it's reportable, whatever, if you suspect it, report it. But what I was saying is that sometimes when you, I guess, take in that whole signals of well-being, how maybe if this guy were to come up to Lula now, she would smile at him and engage with him with non-verbal communication, but it's just because she's maybe forgotten because
Yes,
her memory
yes,
is,
you know.
not what it normally is. She's forgotten that he assaulted her. So that's what I'm saying, that even if you can't tell overtly that something's happened, you should just report it anyway.
Yep. And also, it is also possibly grounds to ask George to leave, and in this case. So.
And it's such a... If he did leave, and depending on the level of dementia and what she can show behaviourally, it'd be interesting to see if she showed any signs of being sad or affected by that person not being there anymore.
Yeah, it may be that she was happy with the situation. I think it's difficult where you've got, it's the case where one person does have that capacity and another one doesn't, because there's definitely that vulnerability there. Yeah, so, but yeah, that's the other way to look at it as well. So maybe that she is consenting, but yeah, presuming she doesn't, then I think we could say there is that injury. Not an easy argument though to have.
So when we are saying that they have to leave, are they leaving, going where? Are they going to another nursing home? Do we give the reports about what happened? Do we hand over to that nursing home?
So you could only do that with consent, probably in your resident agreement, or there might be something in your resident handbook, for example, that talks about if someone goes somewhere else and you provide that health information. I'll get to just on what the actual steps are. So this is just really emphasising the points I've been making here, that it's the wrong or injustice suffered or the infringement of the rights of the victim, and that the indecent contact is serious given the nature of the wrong act and infringement of the victim's rights. And that's been recognised in criminal cases. So once you've decided you're going to ask George to leave, you have to have his care needs assessed, and this is about determining where it is that he should go, and it may be that he should go to a place that deals with more challenging behaviours. You have to get George assessed by either an aged care assessment team or at least 2 practitioners, one of who's independent of the provider and chosen by the care recipient. One of the difficulties with this is that if George says, no, you're not assessing me, that's quite a difficult situation. The security and tenure provisions are quite difficult to overcome these hurdles. But it may be that through the process you get George to agree to undergo that assessment. Whether you use the 2 medical practitioners or the ACAT will probably depend on your relationship with the practitioners, but one of them is going to be chosen by George, so you have to bear that in mind. And what if they disagree? Sometimes an ACAT can be a better option. I think what you should also be mindful of when you're doing this is also just making sure that the assessment team, the person assessing him, actually considers, is George appropriate to live in this type of environment? Sometimes the reports won't necessarily look at that aspect, and it's not that we can't say that that's what it means, but it's helpful if they actually specifically say George would be suited to X, Y, Z environment, a specialist unit or something like that. Then you have to follow certain steps before you can ask him to leave, and that's so you have to serve on him a written notice of your decision to require him to leave, and it has to set out certain things, including the decision, the reasons why, and when the resident is to leave, which must be at least 14 days after the notice is given. Also, that you have to tell them about their rights. So you can't require him to leave until suitable alternative accommodation is available. So serving the notice is not of itself sufficient.
Can he challenge it?
Not the notice per se, he could make a complaint about it. He could write back and say, I don't agree with this, but the fact you've served it and you say you've got grounds, that, provided, for example, the department doesn't disagree, that is in itself sufficient to meet your responsibilities under security and tenure provisions. Although the principles are not entirely clear, practically speaking, the obligation to find suitable alternative accommodation often falls on the provider. Families will rarely actually take those steps. I think that, finding a place as soon as possible that is available, maybe at the same time you're having them assessed, ring up the Carina or the like and say, do you have space available? That will help. And just be aware too that suitable alternative accommodation doesn't mean George's family have to like it. They don't have to agree that it's the best place for him, provided you've got that, you've found a place at somewhere that's suitable according to the assessments, that's going to meet your responsibility. So whether they accept it or not is really beside the point. It has to obviously be affordable by the resident, but that's not really going to be an issue if it's an aged care facility, because it's, as you know. So, I'll just see. The one case where a notice to leave could be revoked is where the resident changes their behaviour. So if George stops doing anything like this, perhaps you could revoke the notice and say, okay, we accept you can stay now. But maybe leopards don't really change their spots. The other one I spoke about was where they no longer provide accommodation care suitable for the care recipient having regard to his long-term assessed care needs. So I've spoken about the assessment, but basically that means you haven't, it'll only apply to where you haven't agreed to cater for those level of care needs. And I think this is a little bit tricky now because we're no longer at high care, low care. Yeah, so it's a little bit, I'm not quite sure how it is they're expecting that will work, but I'm thinking it'll be things like if someone has serious psychogeriatric needs and that's not within general aged care sort of services, then perhaps that's where you could say we didn't agree to provide you with these services that you need. But it is a little bit unclear now, I think, because usually it was that where someone's care needs and then became high care. Does anyone have any questions about that security of tenure? It's a difficult issue and unfortunately results in a lot of complaints. But the most important thing is that you do identify that ground. Why are you asking George to leave? It might be both of those reasons. And in this case it could be because we've had a sucker that, once we get him assessed, and if someone says that he shouldn't be within a normal aged care facility, then we've got that ground. And just those would be my tips around it as well. Get the assessments as soon as possible, ensure they address the issue of where he should live, and also try and find some alternative places so that that's not another 6 weeks, because as if you imagine, some of these, well, as you would know, some of these residents can take up a lot of time, and